Someone passes away. The family is grieving. The lawyers are involved. The house is sitting there in probate. And meanwhile, quietly in the background, the property tax bill keeps stacking up. And nobody is talking about it. If you've inherited a property or you're about to, this is the part of the process most people learn about the hard way. So today we're breaking down exactly what happens to property taxes during probate, who's actually on the hook, and what can go wrong fast if it gets ignored. Here's the first thing you need to understand. Probate doesn't freeze the property tax clock. The county doesn't care that the deed is tied up in court. They don't send a sympathy card. The tax bill comes out every November, just like always. In Florida, taxes are mailed on November 1st. You get a discount if you pay early. 4% in November, 3% in December, all the way down to 1% in February. After April 1st, those taxes are officially delinquent. And from there, things start to escalate fast. So while the family is dealing with attorneys, paperwork, and grief, the meter is running on that property whether anyone's paying attention or not. Now, who's supposed to pay these taxes during probate? Legally, the estate is. The personal representative, sometimes called the executor, is supposed to pay property taxes out of estate funds while the case moves through court. The catch? A lot of estates don't have liquid funds. The big asset is the house itself. So either someone in the family fronts the money out of pocket or the bill just doesn't get paid. And that's where families get into real trouble. Because the estate's responsibility on paper doesn't help anyone if there's no cash to cover it. Let me walk you through what actually happens in Florida when those taxes stay unpaid. April 1st, taxes are delinquent. Penalties and interest start. June 1st, the county runs a tax certificate auction. Now, this is not a sale of the house. Not yet. What's being sold is a tax certificate. Basically, an investor lending the county the unpaid tax amount in exchange for interest, sometimes up to 18%. That investor now holds a lien on your inherited property. Here's the part that catches families completely off guard. After 2 years, the holder of that tax certificate can apply for a tax deed. And once they do, the property goes to a tax deed sale, a public auction where the house can be sold to the highest bidder to pay off the tax debt. So if probate is dragging on, and Florida probate routinely takes 6 to 12 months, sometimes a year and a half on contested estates, and nobody is paying those taxes, the family can literally lose the house through a tax deed sale before probate even finishes. This is real. This happens in Miami-Dade and Broward every single year. And it's almost always avoidable if people understand the timeline early enough. Here's another piece nobody warns you about. The Homestead exemption. If the person who passed was claiming Homestead, and most Florida homeowners are, that exemption was reducing their taxable value and capping their annual tax increases at 3% under the Save Our Homes rule. When that owner dies, what happens to all of that depends entirely on who inherits. If a surviving spouse inherits and continues living in the home, in many cases, the homestead and the Save Our Homes cap can carry over. But if the property goes to adult children, siblings, or anyone who doesn't make it their primary residence, the homestead exemption is gone. And that Save Our Homes cap resets to current market value. In Miami-Dade and Broward, where market values have absolutely run away over the last decade, that reset can mean the property tax bill literally doubles or triples overnight. I've seen cases where the parent was paying $3,000 a year in taxes, and after the reset, the kids are looking at $9,000. Same house, same address, 3 times the bill. So even if the family pays everything on time, the ongoing carrying cost of holding that inherited property can become brutal, fast. So what can you actually do about all of this? You've basically got 4 paths. 1. Pay the taxes out of pocket and keep the property moving through probate. This works if you have the cash and a clear plan to either keep the house, rent it, or sell it after probate closes. 2. Petition the court for permission to sell the property during probate. In Florida, you can do this with a court order, and it can stop the tax bleeding while probate finishes up in the background. 3. Wait for probate to close, take title, then deal with everything. Risky if the timeline is long because every month of inaction is interest, penalties, and potentially a tax certificate stacking up against you. 4. If the math is genuinely not working, meaning the holding costs, the deferred maintenance, the mortgage if there is one, and the tax bill altogether outweigh the equity, selling the property, even mid-probate, can be the cleanest exit. There's a process for that, and it's more common than people think. Look, none of this is meant to scare anybody. The whole point of this channel is to give you the information you should have gotten from the attorney's office, but probably didn't. If you're dealing with a probate property right now in South Florida, the most important thing you can do is get clear on 3 numbers. What is the property actually worth today? What are the carrying costs? taxes, insurance, utilities. Every month it sits in probate. And how long is probate realistically going to take? Once you know those three numbers, the right move usually becomes obvious. If you've got questions about a specific situation, drop them in the comments. I read them and I answer them. I'll see you in the next video.